Now to a battle on a different front, that of the courts. College campuses could get more white and more Asian in the coming years, and some say that would be the most fair and right thing to do. I'm talking about possible changes to who winds up on those campuses, based on a decision just made by the Supreme Court yesterday to put on a particular case onto its fall docket. A group called Students for Fair Admission says Asian Americans trying to get into Harvard have been hurt by the same practices that have helped Black and Latino students, practices used to enrich the campus environment through diversity. Much the same arguments are being made by affirmative action challenges at the University of North Carolina. Here to help us understand the implications is attorney Candace Fields. Thank you for joining us this morning.
Thank you. Good morning.
The Supreme Court will now reconsider race-based affirmative action policies and college admissions in cases tied to a public and a private campus. This has the potential to literally change the complexion of college life nationwide. In the Harvard case, the challenge is to Title VI of the 1964 Civil Rights Act, which prohibits schools from discriminating on the basis of race, right?
Exactly. Yes. Well, it has been the law of the land for over 40 years that schools are allowed to make decisions that permit them to enroll students of color, of race, over white students in certain situations based upon plus factors that allow them to look at a student for various factors, including race.
Okay. The case tied to the University of North Carolina references the 14th Amendment, which guarantees equal protection under the law. How does that apply here, and why doesn't that principle provide that Black and Latino students have an equal shot to be on campus at UNC or any place else?
Well, the difference between the challenge to Harvard and the challenge to the University of North Carolina is that Harvard is a private university, whereas the University of North Carolina is a public, a state university. Therefore, slightly different laws apply. You would base your understanding of the last 40 years of law on both the Constitution, equal protection under the law, as well as federal statutes that would apply to Harvard, University of North Carolina being under the Constitution. In this case, what we're finding is that the organization, who is the plaintiff, is claiming that it is illegal, unconstitutional, to allow schools to make the selections based upon affirmative action principles.
As lawyers have worked on these cases and affirmed affirmative action in the lower courts, one argument has been that race is only one factor, as you were kind of pointing out, one factor in admissions. How can that limited use make the case for fairness in what's happening right now with these other two cases going on to the fall docket for the Supreme Court?
Well, I mean, the argument is that at this point in our society, we do not need to be determining who gains admission to colleges based upon race, that the time has come that we no longer need to give an advantage based upon race. However, ironically, Harvard has been the gold standard for these affirmative action programs, and the United States Supreme Court has previously ruled that their use of plus factors, not only race, but also athleticism, community volunteerism, these plus factors are permitted to create diversity on campus, an appropriate goal. The plaintiff here is indicating that no, that is not fair to the rest of the student applicants who deserve the same fair analysis as minority students.
Going to be a lot for the court to consider and colleges to consider, as they may have to reshape how they're looking at their admissions. That also happening with them kind of changing the SAT today, but definitely a topic we'll check back in with you about. Thank you so much for joining us this morning.
Thank you very much.